Patricia Van Haren, family law attorney. My spouse refuses to follow the child custody orders that were set forth in our final judgment. Is there anything that I can do about that? The recurring violation of custody and visitation orders can be grounds for a change in custody. If a parent is consistently making legal decisions, such as where the child goes to school, enrollment in mental health counseling, or changes in doctors without the knowledge or consent of the other parent, this may be deemed a violation of the orders for joint legal custody. There may also be orders that the parents are not allowed to drink or use drugs in front of the children, or they are not to make disparaging remarks about the other parent in front of the child. A violation of these court orders may be grounds for filing a motion for contempt or a request for order to change custody or visitation for the minor child. In cases where there are court orders for visitation or physical custody of the minor children, the court expects both parents will comply with those orders and will cooperate with each other. If circumstances change, the parents will need to modify those orders. Without going back to court or signing a written agreement which modifies custody, these orders are enforceable orders of the court and they must be complied with. A parent cannot choose to violate court orders simply because they are angry at their former spouse. Additionally, they cannot unilaterally choose not to send the children for their visitations. The courts have long determined that custody and visitation is a right that belongs to the children, not just the parents. Courts have upheld that consistent denial of custody and visitation rights belonging to the other parent are grounds to find that that parent is unfit and should not have custody of the child. While the police will not enforce a court order and physically make the parent turn over the child to the other parent for their custodial time, they will take a report for violations of the court order. These reports can then be attached as evidence to the filing of an order to show cause regarding contempt. Further, you may follow up with your former spouse through email, text message, or your online communication program to document the violations of your custody and visitation orders. Each violation of a court order will be considered an additional count of contempt, and those will be specifically pled in your contempt action. A contempt action is considered to be a quasi-criminal action. Therefore, the party in contempt may have jail time, payment of attorney fees and costs, or the court may choose to modify custody entirely based on the severity of the contempt. It is important to document all the evidence if your former spouse continues to violate these court orders. All of that evidence may be used in the hearing on contempt and the request to change custody of the minor children. We had a case where the father consistently refused to turn over the children when his custodial time was up. When we filed our case in court, we were able to provide evidence of police reports, the communications between our client and her former spouse, and the communications from our office to the father. The court determined that since the father refused to comply with the court orders, it was in the best interest of the children to be with their mother and for the father to have supervised visits in order to ensure the children would go home at the end of each of these visits. If you have any questions about violations in your court orders, shoot us over an email or give us a call.